Is there a cap of what your land/homestead is worth to allow you for Medicaid? We are in Texas and have property in a ladybird deed. Okay, so I'm not positive for Texas because I don't practice in Texas, but I know in Florida, the current cap in 2025 for the equity in homestead owned by an individual is $731,000. So Texas may have a similar rule, but essentially what that means is if an individual owns the property by themselves, then the amount of equity that they have in the home, and equity is the fair market value of the home minus any debt associated with it, such as a mortgage. So the equity that you actually have, what its value is to you. Like if you were to sell it, how much would you actually get, or how much could you take out on credit for if you had a line of credit? So your equity, again, it's the fair market value minus any debt owned on the home, cannot be greater than $731,000 for an individual in order for that homestead to be exempt. So they can exempt up to that amount. Now, if there's a spouse, there isn't a limit. So if you have a spouse, and of course, if your spouse is living at home, you don't have to worry about this limit. Also, if there's a minor child at home, this policy isn't going to apply. Now, I'm glad you brought up the ladybird deed because there's another aspect here. Just because you qualify or can qualify for Medicaid, because let's say you are an individual and the equity in your home is not greater than $731,000. That means it won't be a countable asset in order to get you accepted for Medicaid. But that doesn't mean that Medicaid may not try to recover from that asset, especially if it has to go through the court process called probate when you pass away. And probate occurs when you pass away owning assets in your name only, so no joint ownership, and they don't have beneficiaries tied to them or payable on death recipients or transfer on death recipients. A ladybird deed is a way to actually have a transfer on death recipient on a deed. So when you have a ladybird deed, whether this is Florida or Texas, it makes it so that upon the owner of the property's death, the property goes directly to whoever they named as the beneficiary, whoever they listed on the deed, who gets the property after they pass away. Because they list someone and because these deeds are allowed, and they're essentially transfer on death deeds, meaning the transfer happens immediately upon death, it avoids the probate process. So your house doesn't ever go into the probate system, therefore Medicaid can't make a claim against it. The neat thing about beneficiary designations, true fact, is when the original owner of the asset dies, the beneficiary then becomes the owner. So it's instantaneous. If you're able to actually list a beneficiary on an asset, including a home, that person becomes the owner immediately upon the original owner's death. So that means that that asset is now that person's. So if the original owner who passed away owes debts, it doesn't come from that asset because that asset isn't part of what they own anymore and does not become part of their estate or monies that would have to transfer to other people or to creditors through the probate process. So that's just a good thing to have in mind in general, especially for people who maybe don't have the money to get a trust in place. One thing you should absolutely do is go and list primary and contingent or secondary beneficiaries on everything you own. If you are in a state that allows ladybird deeds like Florida and Texas, or you're in a state that allows transfer on death deeds, which are essentially, very similar type deed, that means you can actually name beneficiaries or remaindermen, someone who can take the property directly after you pass away. Go see an attorney and have the deed done and have it done properly. This is going to save so much stress and money and time associated with probate. So you always want to make sure you have those beneficiary designations. So this will be important in this homestead example here, because if that homestead has a beneficiary through a ladybird deed, then Medicaid won't be able to reclaim it through a probate process. But as far as what the limit is for Texas, definitely contact someone in your area who practices elder law. They would be able to give you that information. I'm sure if you Google, there's also going to be agencies that are going to put information out there, updated information for the new 2025 limit. So you should be able to find how much equity you can have a home in Texas in order for it to still be considered exempt from the Medicaid application process. All right, I hope this helps. If you have any other questions about Medicaid or elder law in general or estate planning or asset protection, please don't hesitate to reach out to our office. If you're in Florida, we are at atCAUSE Law Office, the non-stuffy attorneys, and the link is in my bio.